Hello viewers, welcome back. This is Subathra Mylsamy, partner at AK Mylsamy and Associates. So today's topic is going to be a very interesting topic, which is on the living will concept. I'm sure all of us have heard about wills, where the wills come into existence only after a person dies. But the living will concept is a person executes the will in case if something later on in their stages, say any medical ailments come into place, how they have to be treated. So this is the concept of a living will. Now shortly, let me dive into the entirety of the concept. As I mentioned before, living will is a person's right to make a directive about the course of their medical treatments, including the removal of their life supports if any situation like this arises. A living will is otherwise also known as an advance medical directive. It is a legal document that specifies the type of medical care an individual does or does not want if they cannot communicate their wishes. In the case of an unconscious person who suffers from a terminal illness or a life-threatening injury, doctors and hospitals consult the living will to determine whether or not the patient wants life-sustaining treatments such as assisted breathing or tube feeding. Now, what are the legal recognition of the living wills in India? Now, a living will is a legal document that is recognized and enforceable in many countries and jurisdictions around the world. The legality majorly depends on the specific laws and regulations of the jurisdiction. For example, in some countries, living wills are generally recognized as legally binding documents that can be used to guide medical decisions and end-of-life care. It is important to note that the laws and regulations governing living wills in India are still evolving. So there is only one particular provision under the Mental Health Care Act of 2017, which clearly talks about the advance directives. And this advance directive under this act clearly states that if a person later on in their lifetime becomes unsound mind, then the directive can be enforced. So as per this act, an advance directive is defined as any person who is not a minor has a right to make an advance directive in writing, specifying the way the person wishes to be and not to be cared for and treated for a mental illness. And they also can specify any individual or individuals whom they want to appoint as his or her nominated representatives. I'm going to talk about the recognition of right to make a living will, how it came into play. Now in 2018, the Supreme Court in the case of Common Cause versus Union of India recognized that the right of an individual to make an advance directive or living will and directed the government to frame guidelines for its implementation. The court also held that a competent adult has a complete right to refuse any kind of medical treatment, even if such refusal may cause death. The court also directed that in case of any dispute, the matter should be referred to the high courts for resolution. Moreover, once again, few changes have been brought into in the said guidelines in January 2023 by the case filed by the Common Cause Society once again. The guidelines given by the Supreme Court cover a large aspects on the concept of how to make the living will. Here I'm going to only talk about most important concepts. One is who can execute the advance directive and how it has to be executed, when and by whom it can be executed, and what happens if the medical board refuses the advance directive. Who can execute the advance directive and how? The advance directive can be executed only by an adult who is of a sound mind and healthy state of mind, and in a position to communicate and comprehend the purpose, the consequences of executing the document as such. It must be voluntarily executed without any kind of coercion or inducement or compulsion, and also after having a thorough full knowledge of the information. It shall be in writing, clearly stating as to when the medical treatment must be withdrawn. It should be in specific terms and instructions must be absolutely clear and unambiguous. The document must be signed by the executor in the presence of two attesting witness and attested before a notary or a gazetted officer. This is the most crucial aspect in the advance directive for it to be executed in the later stage. When and by whom the advance directive can be executed. So in the event the executor becomes terminally ill and is undergoing a prolonged medical treatment with no hopes of recovery and cure of any kind of ailment and does not have a decision making capacity, then the treating physician, once he is aware there is an advance directive in place, shall ascertain first the genuineness and the authenticity of the document from the magistrate of that particular jurisdiction before acting upon it. So like the way in a normal will, once it is executed, if the executor feels later on wants to change the will, and only the will which has recently been executed will come into play. The same concept is also used here in the advance directive. So here also the executor shall revoke that living will or the advance directive at any stage before it has been acted upon or implemented as well. Once the physician comes to know that the living will is genuine, then the same is being reviewed by the medical board. Now what happens when the medical board refuses the advance directive? If the permission to withdraw the medical treatment is refused by the medical board, it would be open to the executor of the advance directive or his family members or even the treating doctor or the hospital staff to approach the High Court by way of writ petition of Article 226 of the Indian Constitution. Now the High Court shall render its decision at the earliest, specifically keeping in mind the principles of best interest of the patient. Let us see the legal status of living will in the other countries. Now in the United States of America, a living will is defined as the same as in India. The laws surrounding the living wills may vary state to state. Living wills are recognized as legally binding documents in all 50 states and in the District of Columbia as well. In United Kingdom, people may make an advance directive or appoint a proxy under the Mental Capacity Act of 2005. This is only for an advance refusal of treatment for when the person lacks the mental capacity to be legally binding. The advance decision must be specific about the treatment and is being refused and the circumstances in which the refusal will apply. In Germany, the German Federal Parliament passed a law on the advance directives applicable since 2009. This law is based on the principle of the right of self-determination, which provides for the assistance of a fiduciary and of the physician. In Japan, advanced healthcare directives are not legally recognized. In Switzerland, there are several organizations which take care of registering patient degrees, forms which are signed by the patients declaring that in case of permanent loss of judgment, all means of prolonging life support shall be stopped. In 2013, a law concerning the advanced healthcare directives has also been voted. To conclude, it might be difficult for some of us to take such a call, but we should keep in mind that the right of a dying man is to die with dignity when life is ebbing out. And in the case of a terminally ill patient or a person who is in a persistent vegetative state, where there is no hope of recovery, accelerating the process of death for reducing the period of suffering constitutes a right to live with dignity. The general population of our country itself is not aware of such a provision which is in law. It is imperative to create this awareness amongst the masses regarding the guidelines for making a living will. I hope this video would have been informative for you all. Thank you so much for watching. See you. Bye-bye.